Chair. We will now move to 5-minute questions. The Chair recognizes the gentlelady from Wyoming.
Like other federal agencies, the FTC has a designated agency ethics official known as DAO. On April 18, 2023, you testified before a subcommittee of the House Energy and Commerce Committee. At the hearing, Chair Rogers asked you, quote, "Are there any instances where you have not followed the DAO's advice?" End quote. You responded no, and you followed up by saying that you, quote, "have consulted with the DAO and taken actions that are consistent with the legal statements that DAO has made," end quote. On June 16, 2023, a Bloomberg journalist published a leaked memoranda written by the FTC's DAO analyzing Chair Khan's ability to sit as a judge in the FTC's review of Meta's acquisition of a company called Within. According to the ethics memoranda, the DAO, quote, recommended you recuse to avoid an appearance of partiality concern pursuant to federal ethics regulations. Do you believe that you were completely honest and forthcoming with Congress when you asked if there were, quote, any instances where you had not followed the DAO's advice, and you answered no? Yes or no?
Yes, Congresswoman.
Okay. In the letter that you sent to this committee yesterday evening, you claim that you received only oral advice from the DAO, but never saw the leaked memo until after you decided not to recuse yourself. First, it is unbelievable to me that you would not ask for written ethics advice on this particular topic. You admit that you have written ethics advice on other topics, but on this topic you claim you did not see the written memo. Instead, you want us to believe that you only received oral advice and not specific oral advice, but only general advice on, quote, understanding the legal framework, end quote. Did DAO give you advice that is different than what was written in the memoranda?
Thanks for the question, Congresswoman. So my work before I joined the commission was focused on assessing the power of large technology.
I need you to answer the question that I asked. The question that I asked was, did you receive different oral advice than what was written in the memoranda from DAO? Very simple question.
So I consulted with the ethics official. The ethics official, as was noted in the memo that you cited, although I did not receive that memo, noted that the ultimate framework for instances in which somebody has no financial conflicts of interest.
Did she give you different oral advice than what was in the written memoranda?
The legal framework
yes or no?
is for the employee to themselves determine whether they should or should not recuse.
Did she give you different advice than what was orally than was in the written memoranda? Yes or no?
Congressman, as was noted in the written memoranda, there was no ethics violation created by my participating in the matter.
But you didn't follow the DAO's advice, did you? You could have recused at any time, couldn't you?
I followed the determination that there was no ethics
You could have recused at any time, couldn't you?
There was no violation under the ethics laws because I have not a penny in financial stock, not a penny in financial interest.
The DAO gave you the advice to recuse and you did not do so, correct?
Congresswoman, as was noted in the memo, as I noted in the letter.
I'm going to move on since you're not willing to answer my question. I read your 4-page letter, which was nothing more than an affront to your obligations of honesty, integrity, and candor before this tribunal that is owed by every public servant. And I would reference Part 2635 of the Code of Federal Regulations, which describes your ethics standards. I want to note that the ethics standards are actually higher than one owed by lawyers, which brings me to my next point. Do you expect lawyers at the FTC to follow federal ethics rules?
Of course, everybody at the federal.
Do you expect lawyers at the FTC to be an active member in good standing of a bar of a U.S. state?
If they're practicing as a lawyer, they need to be in good standing with the relevant bar rules.
I understand that you were admitted to the New York bar on July 16, 2020, but in 2019 and 2020, according to your Senate questionnaire, you held yourself out as counsel for the Democrats on this very committee. You used this title, but you were not licensed to practice law. Counsel is a term reserved for lawyers, licensed lawyers. And in Wyoming, a person who in any manner holds themselves as competent to practice law without a license to do so is guilty of unauthorized practice of law. I believe the law in the District of Columbia where you held yourself out is similar. Do you believe it is appropriate for non-lawyers to claim the title of counsel?
Congressman, when I had the honor to work for this committee, I complied with all of the document requests that the HR folks requested, including documentation about the fact that
when I checked your registration status this morning, I learned that you are not in good standing with the New York bar. Your license is listed as delinquent, which means you have failed to file your biennial registrations, and it means that you have not been paying your bar dues, completing your continuing legal education, and maintaining your law license. I believe it's shown on the screen. It also means you're subject to referral for disciplinary action. I find this situation to be stunning and a reflection on your ethics. With that, I yield back.
General Lady yields back. The chair now recognizes the ranking member from New York for 5 minutes.